SJC-12252, Commonwealth v. Joseph Cousin.
Ms. Teo, good morning.
Good morning, Your Honor. May it please the Court, Assistant District Attorney Amanda Teo for the Commonwealth. With me is Assistant District Attorney David Fredette, who is now the trial prosecutor assigned to this case. We're asking this Court to vacate the motion judge's order granting the defendant's motion for new trial because she erred as a matter of law in concluding that trial counsel had an actual conflict of interest which should have disqualified him from representing the defendant in this case. Your Honors, this Court has created a jurisprudence with a deliberately high standard for actual conflict. The conflict must be inherent in the situation such that no impartial observer could reasonably conclude that counsel could serve his client with undivided loyalty. The motion judge here developed two theories of actual conflict, neither of which I would submit rise to the level that this Court set out in that standard. The first is that trial counsel's overlapping representation of an individual homicide detective in the Drumgold civil rights litigation in federal court represents an actual conflict for the defendant. The second is that trial counsel had a personal or financial interest in maintaining good terms with the Boston Police Department or the city of Boston, and that also is an actual conflict of interest that would have disqualified him in this case. Let me take each of those in turn. With respect to the overlapping representation,
Stop you there.
Of course.
Are these cumulative or not? I mean, would the cumulative nature of the overlapping representation and the financial interests be enough?
it would not, Your Honor.
Neither of them alone would be?
It would not, Your Honor. I think the Commonwealth's position is if there is 0 and 0 together, those two add up to 0. Here, I think even if you disentangle the two theories, or even if you put the two theories together, it would not amount to an actual conflict because, again, it has to be one that is inherent in the situation. And as I will discuss, neither of those theories, even in and of themselves, would amount to an actual conflict of interest.
You didn't include the Cowens case in your grounds, and I assume that's because you believe that Judge Sanders did not rely on Cowens.
Your Honor, I think Judge Sanders relied on Cowens insofar as it went to Justice Lang's question, a sort of conflict by association argument where because counsel and his former law partners represented, in her view, a number of police officers, that the entire shop, so to speak, was tainted and therefore could not represent individual criminal clients in state court.
But it's a lot more with that with Attorney Robinson because she represents Officer McLaughlin, who's dealing with fingerprint evidence, and just a few weeks before the trial, there's a disclosure of these fingerprints that were lifted and not turned over. And that information is just about the time that Drumgold is going to trial, where Mr. White's still counsel of record. So I think what I'm trying to say is when you list your reasons, it's important to understand whether or not Judge Sanders was relying on the Cowan situation as well, and whether that goes to Justice Lang's point, which is the cumulative effect, the synergistic effect of all this.
I understand your concern, Your Honor. And let me try it this way. I think Judge Sanders' concern was a sort of overlapping representation or a kind of conflict by association type argument, where counsel's association with the defense of various police officers in various postures and various litigation would have amounted to an actual conflict in this case. And I think it does not here for a few reasons. With respect to Rosemary McLaughlin and Attorney Robinson, the most important thing here is that Attorney Robinson was no longer representing Ms. McLaughlin at the time Attorney White took on Mr. Cousin's case. And not only that, Rosemary McLaughlin was not a witness or a potential witness or on the witness list for Mr. Cousins' case, either the first trial or the second trial. And lastly, Mr. White himself, or Attorney White himself, was no longer in a partnership with Attorney Robinson at the time he took on Mr. Cousins' case. And so there's a kind of a triple, there are triple reasons why any kind of concern or loyalty between the firm of Davis, Robinson, White, or Attorney White himself and Rosemary McLaughlin was terminated by the time he took on Mr. Cousins' case.
So if at the trial of Mr. Cousins, Mr. White went after Ms. McLaughlin, you're saying it wouldn't have been any kind of a problem for him ethically to do that?
Correct, Your Honor, because there was no duty of loyalty between Attorney White and Ms. McLaughlin. Ms. McLaughlin.
She had been a client of the firm of which he had been a member.
Correct, but by the time he took on Mr. Cousins' case, he was no longer a member of that firm.
No, but doesn't that mean you can't go after an ex-client, can you?
Only, and here we look at the professional rules as well as the case law of this court. With respect to the representation of former clients, we can look at Comment 9 to the Rule of Professional Procedure 1.10, that if a lawyer has no confidential information about the representation of the former client, the new firm is not disqualified from the case, and that's precisely what happened here. There is no showing that that Attorney White had any access to privileged or confidential information as a result of Attorney Robinson's representation of Rosemary McLaughlin. The motion judge does not so find, and there was no evidence below that that was the case. So that's the reason why. Of course, Justice Lowy and Justice Link, you are correct that McLaughlin and the fingerprint situation would have been more concerning in this case with respect, would have been more concerning, but because there was no duty of loyalty at the time that Attorney White took on Mr. Cousins' representation, that is not a concern for actual conflict. That would be a different query if this gets remanded back to the motion judge on the potential conflict situation. So returning to the overlapping representation of Detective Callahan, I think the motion judge's theory was that because Attorney White represented Detective Callahan, he was then loyal not only to Detective Callahan in his individual capacity, but also to the City of Boston and to the Boston Police Department. And there simply is not any evidence in the record to substantiate that theory, and there is no case law or rule of professional procedure that would infer that theory to be the case.
Well, would it have mattered? Your brother in his brief, I know you dispute it, we may need to discuss it, says he was retained by the City of Boston to essentially help coordinate the joint defense. I think you say, no, he was retained by Mr. Callahan and the city indemnified him. Would it matter if he had been retained by the City of Boston and was, in fact, retained for the purpose of coordinating a joint defense?
Would have been a factor? Absolutely, Your Honor. And we can look at the Schwartz case out of the Second Circuit that my brother cites, as well as the Wooldridge case out of the appeals court that is cited in our reply brief. Those are two situations in which the actual police association or the patrolmen's association had a retainer relationship with the attorney that ended up also representing the defendant in the criminal case. But in both of those cases, the actual conflict was not found merely because of that retainer relationship. It was found only when the other client became a party in litigation, such that the defendant's position and the other client's position became materially adverse. And that's significant because if we look at the rules of professional conduct, it talks about direct and material prejudice versus direct and material conflict versus general conflict. Only in situations where there is a direct and material conflict of interest between the client and his or her attorney is that an actual conflict. Where there's just general conflict, where there's just maybe a general conflict, such as between competing economic interests, or in this case, between the Boston Police Department and a criminal defendant, that in and of itself does not amount to an actual conflict. This court
I'm sorry, if that factual dispute were to matter, how do we resolve it? I mean, was he retained by the city of Boston, or was he retained by Callahan and indemnified by the city of Boston?
I would assert, Your Honor, that the record bears out that he was retained by Detective Callahan in his individual capacity, and that there was evidence taken on that below. To the extent that that evidence does not show that he was retained by the city of Boston, that is a failure in the defendant's proof. It is a defendant's burden to show that there was an actual conflict. And here, the defendant had the benefit of a full evidentiary hearing of 3 days, and to the extent that there's any failure of proof, that would be on the defendant's burden.
I'm sorry, you just made this distinction between this direct and material conflict versus a general conflict. What case is that we should look at?
Your Honor, that's actually from the Rule of Professional Procedure 1.7.
1.7?
1.7, looking specifically at Comment 3.
Comment 3.
But I do think that the cases with respect to actual and potential conflict do, in fact, enact that principle. For example, this court's Garraway and Hodge cases, those are situations in which either defense counsel or defense counsel's firm were representing simultaneously another witness in the defendant's case. And again, this court did not find that there was an actual conflict merely because of the mere fact of representation, but because those witnesses provided material testimony on a critical issue in the defendant's case, and also because those witnesses, at least in the Garraway matter, one of those witnesses himself was a potential suspect in the case that the defendant was being prosecuted for. If you look to Mosher, this is a 2010 case out of this court, which I think was written by Chief Justice Gantz. There, this court set up a sort of two-pronged standard, one with respect to concurrent representation and another with respect to prior representation. In cases of concurrent representation, this court requires that the representation be of a of a witness for the prosecution who is providing material testimony and on a critical issue in the defendant's case. That is not an issue, that's not the case here, where Detective Callahan was not a witness and played absolutely no role in the investigation of the defendant's case.
Counsel, on this record that we have, if you assumed that we concluded you were correct, there is no actual conflict of interest apparent here, what, if anything, more would need to be done to reach a resolution on the conclusion on the aspect of a potential conflict?
The motion judge in her order specifically granted an evidentiary hearing only on the actual conflict claim. So this court would have to remand to the motion judge for hearing, for an evidentiary hearing, assuming she deemed a substantial issue, assuming that she deemed that a substantial issue was raised by the defendant's motion below on the potential conflict issue. And at that hearing, the defendant would have the burden, once again, of specifying what that potential conflict would be, as well as demonstrating that that specific conflict led to prejudice in his case. And certainly there's been no showing of prejudice thus far.
So the record as it stands would be inadequate to develop any conclusions on that?
I think so, Your Honor, absolutely. Certainly there's nothing in the record with regard to the prejudice showing, which is what the defendant would have to demonstrate in order to...
But the defendant's argument, and I imagine your response is that's a potential conflict, but the defendant's argument is that Attorney White would have been reticent to cross-examine or even call McLaughlin because of issues dealing with obligations to Ms. Robinson and to the firm, and that the problem really is that these prints that weren't disclosed until 2009, the defendant's saying that that just fits right into that peg, fits right into that hole of McAfee's confession, and fits into the hole of the argument that it's Darren and the man who did the killing. That's really where they're saying the prejudice is, that reticence to cross-examine on a huge issue in the case.
First of all, Your Honor is absolutely correct that I would say that that is at most potential conflict. But let me first go back to the basis for Your Honor's question, which is that there would be some obligation to Ms. McLaughlin or to Attorney Robinson. Here, again, there is no such duty either to Attorney Robinson or to Ms. McLaughlin. McLaughlin was not a client of the defendant's attorney, period. And with respect to any connection between Attorney White and Attorney Robinson, that also was not demonstrated by the record. And the Commonwealth's main brief illustrates or attempts to develop why the factual finding that Attorney White was somehow indebted to Attorney Robinson or interested in future referrals from Attorney Robinson simply is not borne out by the record whatsoever. So even the foundation of that question, I think, is not borne out by this particular record. With respect to the two...
Can I ask one question, just on the fingerprint? Lemire does the fingerprint analysis in the second trial, right?
Correct, Your Honor.
And she identifies the second print and Darrell. So isn't this whole issue brought forward in the second trial? How significant is it, I guess, that McLaughlin didn't do a good job in the first trial? I'm just not sure I fully grasp that.
Your Honor, I think, and I don't want to put words in the defendant's mouth, but I think the theory would be that because Ms. Lemire turned over her report about a month prior to the trial of the defendant in the second trial of the defendant, that by that point, Attorney White ought to have been on notice that fingerprint was going to be a major issue at trial. And that he would have been impeded by his former law partner's former representation of Ms. McLaughlin.
Even though they've established all the fingerprint evidence they need, Mr. White has the fingerprint evidence he needs to make the argument about, I'm drawing a blank on this person's name, the witness.
Richardson.
Yeah, the Darrell fingerprint and LeMay's original untaped testimony. All that now is available for him without attacking McLaughlin, right?
Absolutely, Your Honor, and I think that goes to sort of prejudice inquiry. We certainly didn't get into it before the motion judge here because it wouldn't have been pertinent to the actual conflict. But with respect to potential conflict, he had all of that evidence available, and as I argue, I believe in my original opposition to the defendant's motion below, he had all of that evidence available and chose to make the argument that the Boston Police Department conducted a shoddy investigation in this case, rather than colluded actively against his client to manufacture a print or hide a print.
Your time is up, but let me just make sure I understand one thing. If you were to prevail, am I correct that the matter would be remanded to Judge Sanders for a hearing as to whether or not the prong of prejudice has been met with regard to potential prejudice?
Your Honor, I think there needs to be a remand to the Superior Court. Whether that is to Justice Sanders or not, I think is up to this court and also to the Superior Court.
But the issue of prejudice has not been litigated through an evidentiary hearing yet. Am I correct as to that?
Correct, Your Honor.
Okay, she addressed only the actual conflict.
Absolutely. The evidentiary hearing was just on the actual conflict issue, and although I think both parties attempted to lay out some of the evidence with regard to potential prejudice in our initial briefings below this, in the Superior Court, that has not been fully tested.
Okay, thank you.
Thank you, Your Honors. We're asking this court to reinstate the defendant's convictions.
Mr. Shaw, good morning.
Chief Justice Ganson, may it please the court, my name is Robert Shaw. I'm privileged to appear today on behalf of Joseph Cousin. I think at the outset it makes sense to first address why the Commonwealth's approach to the law is simply wrong, and then to look at Justice Sanders' approach to this case and specifically what evidence she grounded her decision on. The Commonwealth's argument that this could not be an actual conflict of interest depends on the notion that actual conflicts of interest are governed by rigid rules that create limited and flexible factual boxes that one needs to fit into before there can be an actual conflict of interest. And if you don't fit into one of those boxes exactly, then what happens is the court says, well, we're going to label it a potential, we're going to label it tenuous, we'll put the burden on the defendant, and maybe the defendant can discern the mental resolve of his counsel and the conflicts within his mind, and the case is acknowledged this may be an insuperable burden and likely will be, but that's okay. That's not the way this court has approached conflicts jurisprudence. It would undermine the principles that govern conflicts jurisprudence. It would undermine our rules of professional responsibility. What the Commonwealth's approach does not recognize is that the duties that counsel has, the duties of competence and diligence, to have undivided loyalty, these are duties that are a product of the representation that that counsel undertakes. They're not defined by or confined to a particular set of facts in an underlying case, nor are they dealing with, for example, just having a witness testify in a proceeding where one is also representing one's client. Now, what did Justice Sanders do in this case? She engaged in a fact-specific, case-specific, fact-intensive inquiry, which is what all the cases do, and she concluded that the obligations and loyalties that were inherent in the representation during Drumgold and the obligations and loyalties that were inherent in the representation during the Cousin case were in conflict. Why were they in conflict? You have to look at all of the factors that were present in this case. And so first, let's do that with Drumgold and then Cousin. The duties and obligations in Drumgold were grounded in the fact that he was engaged in an ongoing contract with the city of Boston, not Mr. Callahan. He was tasked with defending against allegations of misconduct in the homicide unit. The misconduct of the officer he appeared on was part of the evidence against the city of Boston. The city of Boston / BPD bore all liability in the case. The city of Boston and the BPD were actually parties in the case. So he's litigating the case side by side with them. These are non-antagonistic defenses. It's a unified defense. And in fact, his work is the first line of defense against the city's direct liability because of the way the case was structured. And this is taking
Can I ask
place.
you something about that? I'm a little unclear from the record exactly what happened here. We're really talking about like 2 second trials, right? I mean, the reason that Mr. White couldn't represent Mr. Cousins at trial in the Cousins case was, and it was Mr. Cousins' second trial, was because there was going to be a first phase second trial as to whether, as to Mr. Callahan, right?
Well, no.
So could you explain what was going on in federal court? I mean, because I'm not understanding exactly what was about to happen. I know that there was at the first trial in the federal court, the first phase of the way Judge Gertner managed it, the first phase was as to whether or not there was liability.
That's right.
And the first phase was that Mr. Callahan was liable insofar as there was, he was said to have withheld exculpatory evidence, but the jury hung basically on the issue of whether or not it contributed to Guy Drumgold conviction. And I didn't really understand what the new trial was going to cover. What issues was the new trial in the federal court going to cover?
Judge Gertner ruled that the pattern of misconduct within the homicide unit, those were live issues. The initial phase of the trial concerned the individual liability based on the misconduct of that particular officer. And then if there was fault found there, then there was damages and also addressing the pattern of misconduct in the later phase.
But what my question really has to do is, was the whole first phase trial going to be redone at the second?
Yes, it was going to be redone.
So the question of whether or not Mr. Callahan was just liable for withholding evidence.
Well, Your Honor,
the whole.
But Judge Gertner ruled that all of the issues were live. All of the issues were still
live.
She ruled that all of the issues that were live, you can look, we addressed it at the
Okay.
evidentiary
All
hearing, and all of the issues were live. And all of the issues were live because there was still liability at issue against the city and a pattern of misconduct. But going back to my point, you have to realize that the Drumgold case is also taking place. It's an extremely high-profile case. It's being covered extensively in the media, which is a very important factor in this case. Then we have Mr. Cousins' case. it's also a very high-profile case. It is being covered extensively in the media. It's happening at the exact same time. And the Cousin case requires an attorney who can very publicly go after the police department, the homicide unit, essentially what is an environment that is really engaging in corrupt misconduct. And this, again,
That's a necessity as opposed to Mr. Keeler is corrupt and Mr. Callahan's a good officer. Why, I mean, can't you have a one bad apple theory? I'm not sure I've grasped why you have to take on the whole department.
well, Your Honor, there are multiple bases upon which to attack in this case.
Right, but isn't that-
Concerning Keeler in the interrogation of McAfee, the off-tape interrogation of McAfee, misrepresenting and not disclosing the fact that he initially confessed that it was Darrell and Mann, McLaughlin and LeBlanc who have framed an innocent
But doesn't that make it a potential rather than actual? Because you don't really know the best theory. None of this is clear. It just seems like it's more potential than actual, but it's a question, not an
Yes,
answer.
But, Your Honor, the point is that Joseph Cousin is entitled to an attorney that is untrammeled, unrestrained, unburdened, that can investigate, evaluate, and execute on the avenues of defense in his case and is not going to be restrained. That's why it's an actual conflict.
So the actual conflict comes from the fact, not whether in fact he pulled his punches, but whether or not there was reason to be worried about whether he could?
That's correct. When you look at the obligations inherent in Drumgold and Cousin, they are in conflict. They are in conflict. He cannot pursue these accusations on behalf of Mr. Cousin in this highly public arena without acting contrary to the interests of his client and the city of Boston.
So whether he did it or not, we don't know. We don't need to know that, whether or not he did it or not.
You don't, because that's what Justice Sanders is doing. She is looking at the objective circumstances and saying these are inherently in conflict. And not only is she looking at what we've just discussed, but she's also looking at the timing of the events and William White's state of mind.
No.
He's formulating Joseph Cousin's defense when he is fully engaged in the Drumgold case. He's acutely aware of the media attention. The record is overwhelming in that regard. He's aware of the history of the Cousin case. He knows the first jury believed that the police set up Mr. Cousin. He knows that there are substantial grounds to pursue misconduct. We reviewed them in the evidentiary hearing. And he's aware that these two fingerprint analysts have a history of framing somebody, and lo and behold, they did essentially the exact same thing. They didn't disclose prints they pulled off of the car, and 7 years later, he learns for the first time, what do you know, we have exculpatory fingerprints that have now been disclosed.
Now, a number of attorneys represent police that are accused of misconduct, either through the department administratively or in federal court. And a number of those attorneys also represent people accused of crimes. Are you saying that because of the inherent conflict of those people pulling punches, so to speak, that's not permissible?
I'm not saying that, Your Honor, because that only sort of cherry picks a couple basic, very simplistic aspects of these representations. I mean, here we have a very different situation. You have William White, who's under contract. You have him litigating the
So
case.
if someone represented the Boston Police Department, you would have no problem with them defending cases brought by the Brockton Police Department?
It's going to depend upon the circumstances, Your Honor. I mean, these are two very high-profile cases. They're both happening simultaneously. They're both happening and being covered extensively in the media. I mean, what happens?
Just trying to tease out with this pull and punches theory what the limits are, if there are any.
Well, I think there are limits, Your Honor, but again, look, these are happening simultaneously. They're being broadcast in the media. He, on one hand,
What are the limits?
I'm sorry?
What are those limits?
Well, I think the limits are you have to look at the factors in the case. Look at all of the things that I've just reviewed that make this just a terrible situation when you take account of all the factors and don't look at it in more of a generalized way. I mean, these are really extraordinary circumstances, and they're very unique circumstances, which is exactly what Justice Sanders found.
Doesn't the pulling punches conflate the actual prejudice issue? Because when you say pulling punches, you're saying that you don't have to show actual prejudice. You have to show that maybe he might have been pulling punches. That's potential conflict, because to have an actual conflict, you don't need to show prejudice. So we're conflating those concepts.
I don't think so, Your Honor. I think what you're doing is you're looking at the objective circumstances. You're looking at the nature of the representation that William White was involved in on behalf of Mr. Cousin. You're looking at what he knows and the nature of the case and the issues that exist. And you're saying, can an attorney fully investigate and evaluate and potentially execute on those avenues?
Exactly, and potentially. That's exactly right. It may be a potential conflict, but you need to have more than that for it to be an actual conflict.
But, Your Honor, when you have those two circumstances, two cases taking place side by side, simultaneously, highly covered in the media, you have an actual conflict. What is William White going to do if he pursues those accusations and it's covered in the media, and at the same time, the media reports that the attorney of record for Sean Drumgold is attacking the homicide unit, accusing the homicide unit of corruption and misconduct in Mr. Cousin's case, and this is happening at the same time?
Yeah, I mean, you're carefully choosing your words, because he wasn't representing Drumgold at the trial.
He was representing, well, he was litigating the case in Drumgold. He was making an appearance. He was making an appearance on behalf of Callahan. He was under contract with the city. He was litigating the case with the city as part of.
Just pointing out why you were careful in the words you
Well,
chose.
I think I just misspoke, Your Honor. You know, he's under contract. He's litigating the case with the city. You know, the city is depending upon him as their first line of defense. He has professional obligations all the way around.
Is there any reason, I mean, I don't know what the record would suggest about this, but is the only reason that he's not the trial attorney for Mr. Callahan at the second time round of the first phase in federal court because of the timing of the Cousins case?
That's exactly right. It's just a scheduling conflict. He does remain attorney of record. He wants to remain attorney of record.
He expects at the time to go back to representing.
That's exactly right, and that's well established in the record. And I want to take a moment to address the Schwartz case, because it's on all fours and fully supportive of.
Before you get to Schwartz, write it down so we don't forget. Why do you say that he was under contract with the city as opposed to appointed to represent Callahan and paid, whose legal fees are being paid for by the city? I mean, that's a distinction which I think might matter.
Well, Your Honor, the evidence is that he was brought in initially to help all of the defendants, which included the city. He then has a contract with the city. The city receives his invoices every month, reviews his work, determines whether they're going to pay him, renews the contract every year. He is
And is the contract in writing?
The contract was in writing.
And is it part of the evidence in this case?
He didn't produce it. He said he couldn't produce it, that he couldn't find it. But in any event, he testified in detail about it, and there was no concern in that regard. And, you know,
And the contract says what? I mean, there's a difference between I represent the city versus I represent this particular officer, and it's to be paid for by the city. It's the different responsibility of the attorney to the client.
But nonetheless, he is still under contract with the city. It could say that first off, he comes in representing, helping all of them. That's what his testimony is. Then the city directs him wherever they want him to go. First it's Murphy, then it's Callahan. He's taking direction from the city in that regard. You can tell from his testimony, okay? And again, the city is actually relying on his work in a sense as their first line of defense against direct liability. So there really is some professional obligation that goes all the way around, as the cases indicate, that I've cited. Now, this case is similar to the Schwartz case, and I think it's really important to address this because the Commonwealth has addressed the Schwartz case in their reply brief, and there are many inaccuracies in how they've described the case. So I want to address that. First, the attorney in the Schwartz case who represented a defendant officer did not also represent the police union and the president at the same time. In fact, they were barred from a court order, he and his firm, from having anything to do with that case. Second, the individual attorney never had a contract with the union directly. His firm did, and it was imputed to him. That's an important distinction. Third, the attorney never represented the union directly because it was a contract to represent officers in their individual police cases. It's the same thing we have here, where the city hires Mr. White to represent various officers in this case. And fourth, the Second Circuit did not say, as the Commonwealth says in their brief, that the fact of the contract alone was just a potential, not an actual conflict. They say explicitly that we are not ruling on that ground alone because we don't need to, because we have the contract, we have a strong economic incentive, and we have the attorney who has an obligation to the union through the contract and shouldn't be doing anything that contradicts those interests, and therefore we have an unwaivable actual conflict of interest. And in fact, this case is much worse than the Schwartz case. Not only because in this case, Mr. White is involved in both cases, as I've been indicating. He's appeared in both cases. He's litigating the Drumgold case side by side with the entity that he has a contract with, and they're actually relying on him in order to, as a first line of defense against direct liability. They have liability, whether it's whatever the source is. And then again, in this case, we have cases happening simultaneously and being heavily covered
Could
in the
the
media.
evidence in the Cousins case be used in the Drumgold case?
Oh, I certainly think it could have, because in the Drumgold case, they were using the Cowens matter and what happened with McLaughlin. But certainly, I don't think they knew about it. That's another reason why Mr. White would not have, during this highly publicized Cousin trial, attacked the homicide unit in that way and gone after this fingerprint problem, because what do we think that Rosemary Scapiccio would have done when she heard this? And I don't think that it was disclosed to her. Now, there's also the economic conflict of interest, which is an independent...
You're out of time, so why don't you make your last point?
Okay. This was well grounded in the record. The Drumgold case was a very significant source of income for Mr. White over a period of years. He earned over $300,000 on this case. It was his biggest client. Through the relevant time period, it was 50% or more of his income. He testified that he anticipated further work on this case. He wanted further work on this case. He purposely did not withdraw for that reason. And look at the history that he's maintaining here. When he was at Davis, Robinson, and White, that's when he started and first started helping out the police department. They had a referral relationship with the union, and this is something that he wanted to continue. So her decision there, whether independent or looked in the aggregate, was sufficiently grounded in the record.
So on the law, can I just, on the law, I asked the question at the beginning about whether or not it would be cumulative or synergistic, as Justice Lowy put it. Suppose it wasn't quite enough to show an actual conflict, the fact of the dual representation. Can you also add into the mix the other factors, the economic interests, and with that come up with actual conflict?
Of course you can. Of course you can. It's all...
because the comment in return was 0 + 0 = 0, but suppose you're basically saying that's not so.
These were the realistic circumstances of the representation that was taking place. This is what happened. These are what the factors were. And in addition to this, don't forget that we have Mr. White, who when he testified was not cogitating about an abstract matter of law, as the Commonwealth indicates. He was testifying that during the course of his representation, he perceived and he experienced a conflict of interest. He knew that it was a conflict of interest. And to the extent that the Commonwealth is saying that that's not true, it's contrary to the transcript, and it's contrary to what we all understood in that courtroom, and it's contrary to what Justice Sanders credited.
Okay, thank you.
Thank you.
And we'll take our morning break.
All right.